This is JJ Risha with Pismo Ventures, and we are the organizers of the Global Startup Symposium. And I have with me Quan Wen. Quan is a partner at a law firm, an IP law firm in Tucson and in Irvine, California. I will let Quan take over in a second. This webinar, or yes, it's being recorded. So you can always review it at the Pismo Ventures YouTube channel as well after this event is done. Actually, it won't be available till tomorrow morning. Thank you for being part of the Startup Symposium. Like I mentioned earlier this morning, if you were able to see the intro video, we had a great week last week, and we're looking forward to a great week this week. A lot of companies presenting, especially in the life science, which is first day today. We have a lot of companies. We have a webinar. We had a webinar earlier before a panel, I should say, before this one. Now we have a webinar with Quan specifically talking about patents. And then we have another panel right after this at 10 a.m. Pacific time, which is at the top of the hour. Please use a platform to connect, chat, video chat, text chat, book appointments with others. There is a live support button that you can click on, so you're able to get some help for technical assistance. If it's anything related to the event itself, please reach out to us. But if it's technical assistance, please use the support button in the bottom left corner, or if you go inside the info desk, there's also a live chat for support. Quan, this is all yours. Please take it.
JJ, thank you. Thank you, JJ, again for letting me be part of this really cool symposium. I think we've been running this about, oh gosh, 4 years now, right? About 4 years?
It's actually, this is 6 years.
6 years.
You've been part of it for 4 years.
All right. All right.
And yes, I did thank Quan earlier at the previous panel for his support. He's been a sponsor, a great friend, and a great resource for the symposium. Much appreciated.
Well, thank you. Thank you. So, Pismo gets better and better every year. So this morning, you guys had a terrific webinar, a panel discussion on what are some of the to-dos if you're a CEO to make it successful for your startup. And for me, right now, I'm going to talk about winning patent strategies for startups. And after this, there's going to be a webinar, a panel discussion on resources that universities can provide and help for your startups. All right, so as the title for today is Winning Patent Strategies for Startups. The best strategy to have for patents is one that aligns with your investors. The reason is that, number one, they're the ones who are going to fund your company. And so you got to align with them. They got to like what they see. Number two is, as you align with what the investors want, in all reality, naturally, your patent portfolio, your patent strategy will be stronger. It's just sort of how it works anyways. In fact, I can tell you that there is lots of data on companies who have strong IPs will get better exits, and you can look that up. Okay. All right. So let's just start at the very beginning. I think the easiest way to go through this is to go through a patent filing strategy. All right. So when you start filing, you want to file this thing called a provisional patent application. Many of you have probably done this, but let me talk about it and go into depth a little bit more on what is what are the best considerations to file a provisional patent application. First of all, a provisional application is one where you file with the patent office and it sits there. Nobody looks at it. But what you get out of it is you get a serial number, and you get to plant your flag at the patent office to say that I was here on this date with this disclosure, and therefore I I own I own the rights to eventually receive a patent on this invention. And anybody who files after you, you win, okay, on the exact same invention. All right. So when you file a provision application, when do you file it? What do you file on? Can you file just anything? Well, yes, you can. Actually, you can just draw a smiley face and send it to the patent office as your provision application. Does it mean anything? Not really. So what you got to do is to file it at just the right time with just the right content. Not too late, not too early. Okay. It's easy to identify when it's too late. These all are the hallmarks of when it is too late, and you don't want to be there. Number one, well, someone beat you to it and filed it already, or someone beat you to it and publicly disclosed it already, okay? So that you're too late, because in the patent world these days, it's who filed first. And if someone filed before you, they beat you. And if they disclose it, they didn't file anything, but if they make it public information, they beat you. Right? So it's who filed first. So that's too late. Oh, also, you don't want to be disclosing your own stuff either. So there are several there are several disclosures that will compromise your ability to file. Okay. Number one is a public disclosure, meaning that you disclose your own stuff on the internet, show it to somebody who is not under an NDA. Two, a public use. Even if they don't know what's under the hood of your invention, if you publicly use it and produce products out of it and sell it, that's a public use. That will compromise your ability to file. And third is the on-sale bar. If you begin to sell it, even though people don't know what's under the hood, if you sell it, and this happens for softwares for the most part, you compromise your ability to file. That's too late. Okay, you don't want to be there. You want to file before that. Okay. But how much before that? You don't want to file too early either, because if you file too early, you really don't have anything. Just think of a smiley face and filing that. That doesn't mean anything. You want to have it just medium right. So here is where it's too early. You have a concept, you have an idea, but you don't know exactly how to put the parts together to make it work. It's too early. You don't know how to put the parts together to make it work. In filing a patent application, what is really required by the patent office is that you disclose the invention in a way that another person, one of ordinary skill in the art, can read what you have filed and reproduce your invention. That's what's required. Okay, so if you have no idea how it's going to be put together, then someone else reading it wouldn't have any idea of how to put together your invention either. Okay, so then you wanted to just get it just right, where you have an inkling of an idea of how to make it work. Now, do you have to build it before you file it? The answer is no. You can file on your idea, your invention, as long as you write down reasonably enough the steps of how someone else can actually put it together and reproduce your invention. And you don't have to have built it before you file it. All right? All right. So ideally, when you file your patent application, what you should do is you should have two phases. Phase one, make sure that you capture your invention as exactly and technically correct as much as possible. That's phase one. After you're done with that phase, phase two is look at it, step back, look at it, and figure out how a competitor would work around your invention. You want to think about all those ways, even if you're not going to make it yourselves, even if it's not as good as your invention, you want to write about the possible designs anyways, because, hey, you know what? That's just building yourself out a better, bigger, robust patent portfolio or patent disclosure, okay? So that's phase two. That's considering what your competitors can do. So what about you well, all right, a year from now, what would you do? What's your wish list? 5 years from now, what's your wish list? Write all those things in as well. Remember, you don't have to have built it before you file it. So, well, why not write it all in there? So that way you have this coverage projecting deep into the future, right? Okay, so a provisional application will have a 1-year runway until you convert it to a normal, formal non-provisional application. And at the conversion time, and you had to convert it if you want to continue with it. If you don't, if you miss that deadline, then it goes abandoned. And that's it. That's the end of it. The provisional application expires, and you don't get anything out of it anymore. But if you convert it and claim priority to the, if you convert it and the conversion claims priority to the provisional, then you will get the early filing date of the provisional. Okay. So now, when you file your non-provision application or the formal application, if possible, reserve some cash to make it an expedited examination request. And the reason for this is that when you approach an investor, they will ask you, is your invention patented? Well, when you file an application, it takes about 3 years for the patent office to work it through to actually get some sort of resolution for you, yes or no. Let's say you get something granted. It's going to be about 3 years. And before those 3 years, you're going to be out there struggling to get investors. And if you have a patent in hand, it'll be very helpful. And if you don't, it's going to be one of these things where the investor goes, well, we don't know if your invention is patentable or not. So what you want to do to accelerate the process to get the result on your application as soon as possible is to file and request an expedited examination. And that's going to cost you an extra $2,400, let's say $3,000. Okay, that's the government filing fee, $3,000. With the expedited examination, you're going to get red carpet treatment. They're going to get your file in instead of a 2-year waiting period of a review. It's going to be within about 6 months or so, and then they're going to roll out the red carpet for you and then to talk with you and so on and so forth, which is really important because of that accelerated time frame. You'll get your answer very quickly, and most likely, if you do it right, you're going to get your first patent within a year after filing or conversion, which is really nice because when the investors ask you, is your invention patented, you don't have to beat around the bush and say, yeah, my patent attorney say so, and so on and so forth, right? You would just show them the patent, end the story, right? That's the answer for the investors. JJ, I saw our friend Greg had a comment. Did I miss something? Anyways, JJ, if I miss anything, just let me know. By the way, this is I intend this this webinar to be a dynamic one. Please feel free to ask me questions along the way. I love it. All right. So just JJ, if there are questions, let me know. I'm happy to answer along the way. Okay. So the other thing that investors like is for you to have an international patent position. So what that means is at the time of conversion, you should also consider filing a PCT application. It's a patent cooperation treaty, which means that any countries in the world, well, not any, but many countries in the world who belong to this PCT organization or group or treaty would be part of this and could be rolled into your filing eventually. Okay, so let's talk about the cost. So already we highly recommend that you allocate about $3,000 for government filing fee on top of the legal fees, of course, to request an expedited examination because it's all that worth it. Okay, it is a real good investment for you to get that first patent. On the latter ones, you can just go the normal route. The first one, highly recommend expedited examination. PCT, highly recommend as well. It's the government filing fees for that is going to be about another $3,000. Okay, so we're looking at 6 already. The PCT, this is why it's important. When you file a patent application or when you get a patent, it is jurisdictional, meaning that whatever patent that you get would be only good for the country that you got it in. So if you file only in the United States, you would only have patent rights in the United States. So if someone were to make products in Europe, in Canada, in Mexico, in Japan, anywhere else outside the US and sell it in those jurisdictions, you can't do anything about it. Okay. A lot of times, the United States is a big enough jurisdiction or a big enough country and big enough sales that who cares about the rest of the world? But having the patent position in non-US countries would help you with the exit. And this is why. So when companies eventually, I would assume that many of you who are in this game basically want to build your company to a point and sell it to an acquisition partner, right? The acquisition partner, they would like, well, they're like the Johnson and Johnsons of the world. They're like the Edward Life Science. They're like, you know, these big multinational corporations who got sales everywhere, stretching across the globe. They just don't play in the United States. They play everywhere. And if they're going to have sales in Europe, in China, in Japan, in Mexico, and Canada, they would like to have protections over there as well. So you are setting it up for them. Okay, so spending that $3,000 is an investment in which later on, when an acquisition partner comes along, they're going to look at that. And they're going to say, hey, you know what? We're going to, well, you know, you have more than just the US. We're willing to pay you a premium for the countries extending beyond the US. All right. So how does the cost consideration work out for the PCT? It can get fairly expensive. So you start out with $3,000 as a government filing fee to file your PCT application. So it's a holding pattern, okay? You don't have any quote unquote international patent applications yet, not in any country. You only have an option to do so. So it's a holding pattern. The PCT is to hold your position. When you file the PCT application, which is usually 1 year after the provisional, then 18 months after that, or a year and a half after that, so now you're looking at 2.5 years since the date of the provisional filing. So 18 months after you file your PCT, that's when you have to enter national stage. National stage is when you have to pick countries in which to pursue your patent application in. So these are the usual countries. The European, the EPO, it's not just a country, it's actually a cluster of countries. So if you elect the EPO as one of the jurisdictions, then you get France, you get Spain, you get Italy, and so on and so forth. So it usually runs about $15,000. Now, remember, this is about at the point of 2.5 years. So hopefully by that time, you'll get some investors who can help you carry that load, okay? So this is kicking the can down the road. At the 1 year mark, you file PCT, you carry about $3,000 government filing fee plus the legal fees. But then 18 months later, that's where the big dollar is going to kick in. If you elect Europe, it's going to run you about 15 to start. If you elect Canada, it's going to run you about 7. If you elect China, it's going to be about 15 because of translation. Japan, same thing. Mexico, about 5,000, so on and so forth. Okay, so that's where the big dollar amounts come in. And for you, to make a decision on where to file internationally, you should look at 2 things. Number 1, what is your sales volume in that country for your product? I mean, if it's something that that particular jurisdiction don't care about, then there's no reason to file it, okay? Number 2 is, will you be manufacturing out of that jurisdiction or country? If you are, then it's a good idea to file there. So that way you can have some protection of where you're making these things to, okay? And typically what you can do is to determine the countries that would be good candidates for you, you identify the candidates who are potential acquisition partners. Okay, look at Johnson & Johnson, look at so on and so forth, and go to the particular line of products that they have, and look at where they file for that line of product. And if they do country X, you do country X. If they do country Y, you do country Y, etc. That's how you best get a gauge of where you should be filing, because they've done their homework for you. Okay, so that's that part. All right, let's move on. Now, the next stage after you file the patent application is called the prosecution stage. It's not like putting anybody in jail. I know the word sounds scary, but prosecution is negotiating with the patent offices, whether it's U.S. or Canada or EPO or anything like that. So it's prosecution. Now, in the U.S. in particular, you can always request an examiner interview. Okay. One of the most difficult things about getting a patent is it costs so much money just cycling through what we call the purgatory of prosecution. You just cycle and you spend so much money trying to explain to the patent examiner and try to get your patent allowed. And usually what happens, why it happens like that, is that examiners are very smart people. It's just that they're overwhelmed. They have a quota. They have so many hours to review all these things, and they have all these cases they have to keep up with. And as such, they do not have a lot of time to spend to understand your invention. And when they don't understand it, they're not going to grant it. Okay, they're going to pull up all sorts of prior art to say that, hey, your invention buzzword is similar to the other patent application or patent that's got this buzzword, and therefore they must be the same. So the nuance of teasing out the differences between your invention and the prior art that the patent office finds, you best can help them by calling them up and explaining it to them. And that's called an examiner interview. So in the US, it's a very easy process. You connect with the patent examiner, and you basically write like 1 or 2 sentence explanation of what you want to talk about. Is usually talk about overcoming some sort of a prior art, and you make your communication with them as compact, easy to understand as possible when you get on the phone or a video interview with them, to identify these differences between your invention and the prior art that they find, and just tell them, walk them through why it is that your invention is either superior or different than the prior art that that they have found. That saves time for you, and that translates into saving money for you. And that is really good because you get your patent fast and you're not stuck in this prosecution purgatory. All right. Okay. Now, one other tip for investors' purposes and your purposes as well. When you are at the stage of receiving the notice of allowance, when you're there, the next thing to do basically is to pay an issue fee, and you get your patent, right? You get to frame it and all that stuff, and you're done. No, you shouldn't do that. Yes, you can, but no, you shouldn't. When you get your patent, when you get your issue fee to pay to get your patent, before you pay your issue fee, you should file a continuation. And here's why. When you pay the issue fee, it will publish. And if you don't file a continuation or a child, it ends. That's the end of it. And in innovation, and especially in startups, things evolve, things change, things get better. And if you have a design after, you have an improved design after your patent is granted, and you want to, let's say that is a new hot commercial product that you're selling, and you want to file a patent application to cover that new design. Your patent is done with, you don't have a child, you got your original patent, good for you. But if you're going to go to try to file a new patent application on the new design, the issued published patent that you got is going to be prior art against you. So now here's the thing. In innovation, typically a latter design is very much an improvement or modification of some sort of the earlier design. And the patent office doesn't care that the first patent that got issued by you, they don't care that it's by you. All they care about is that it is now public information. And guess what? That public information will be used as prior art against you. So it's going to be you against you. To overcome your own prior art is a bear, because every invention has a DNA. Your latter invention is going to have some sort of a DNA that is tethered or tied to, very overlapping with the first one. So then your own prior art will be what you have issued. And if you don't have a continuation, then that means that the patent office is going to use your own patent against your latter ones that you're going to try to file. So then when you file a continuation or a continuation in part, what you prevent from happening there very much is you minimize the chance, the risk that the patent office is going to use your earlier patent as prior against you, because the new one, the improved one, is tethered to part of, continuation of the first one that you filed. So as long as they're tethered, you're going to reduce that chance of the patent office using it against you in your latter filing, right? So that's why, remember, when you have an issued upcoming issued patent to be granted, or when you pay the issue fee, file a continuation and keep it alive. So that way it can help you to prevent your own prior art, your own patent becoming your own prior art. Okay, two more things that I want to talk about that is really important for investors and for you. The thing about innovation is that, as we were saying, it changes all the time. Today, you invent something, you might think that it's the greatest thing ever and there's never going to be an improvement. Well, you know, 6 months from now, you're going to look at it, I promise you, and some of you have already seen this. 6 months from now, you look at it and say, oh man, that was so primitive. I've got a much better version now. So then when you have that going on, you always want to do an alignment, because this happens so often. And through a due diligence with investors, they will do this, so you should as well, is you look at the commercial product that you have or intend to go with, match it up with the patent filings that you have to see if they are still speaking and they're still on the same page. Often the original filing, because of the original innovation, is going to go this way, is it's going to continue on its merry patent path, and then innovation goes this way, and pretty soon they don't align anymore, they don't match anymore, and that's not good. Because just imagine an investor going in to buy into your company on a product that is successful or is going to be successful, yet there's no coverage because the patent application you filed was 2 years ago and it doesn't match anymore. So you got to do that alignment, and the best way to do it is to have the continuations as going on as well as you get close to the payment of the issue fee. Okay. One last thing. I think I have about 3 minutes before I have to wrap up. So one of the other things that investors ask for all the time is FTO, freedom to operate. Now, freedom to operate, the right time to do it is when you have a product in mind that you're going to commercialize. So regardless of whether you ever get a patent or don't get a patent or do have a patent, none of that matters. The only thing that matters is what you are going to manufacture or practice. When you manufacture something, are you going to be stepping on any third-party patents? You're looking at other people's patents, okay? And so there's also a time, just like when you file a patent application, there's an optimal time to do it. You don't want to do an FTO way too early, okay? And you don't want to do it way too late either. Way too early is when you're not entirely sure what you're going to manufacture or commercialize, because the thing is, in order to do an FTO, or freedom to operate, you have to know what your product is to then match it against third-party patents, right? So get to the point where you have a good idea of what your products are going to be commercially, and then use that to do a search for enforceable good patents. Patents are about 20 years, and see whether any of those claims are going to cover what you have. All right. So I have spoken for about 30 minutes now, and I want to pause a little bit for questions. Are there questions?
So there's a couple questions in the chat, I think. So can you open the chat, or no, you can't? I can read it if you can.
Let me see. Chat.
This is from Greg. Greg said, if you develop a product, but it's 2 years after you filed a provisional patent and nobody else filed a related patent, can you still get patent?
The answer is yes, if it's not publicly known. So you develop a product and it's entirely within your control, with the knowledge of this thing exists within your team only, and it is not public information, then yes. It all has to do with public disclosure. And you can work on something for 10 years, and if it's top secret and no one knows about it, then absolutely, you can still file a patent application on that. And now, one caveat.
Yeah.
Assuming that you haven't publicly used, there's a difference. There's public use and there's public disclosure. Public use is when you create, let's say, a software, and you provide, nobody knows how your software is coded. Nobody knows how your software works. But if you provide a service using that software, then it is a public use. And in the US, if 1 year passes since that public use, then no, you cannot file on that anymore. So anything has to do with the public, you just have to be careful.
All right. Polani says, great summary, lucid description. Polani, you should reach out to Quan, great attorney. Not because he's a friend of mine, but yeah. All right. One more. I think Pratika, are you referring to track one? So I'm not sure what
Yes,
you mentioning. Yeah.
yes, that is track one. So there's also an accelerated examination. There's an expedited examination. There's accelerated examination. Accelerated examination is a bit more cumbersome. That's where you have to do your own prior art search and submit it to them, etc. There's a risk that goes along with doing your own prior art search and submitting it to them because it always exposes you to what's called inequitable conduct, meaning that if you happen to just not find or know of a prior art, and then you submit, five, and then there's a sixth one out there that you didn't know of, and then the USPTO grants you your patent based on the five you found, and the sixth one that you never know of, that actually exists. And if someone else finds it, they're going to say, "Hey, you know what? You guys deliberately hid this." And then that whole issue of did you hide it or not hide it, and so on and so forth. So it is track one, and it is expedited. There is that other thing, but we typically don't recommend it for the reason I just said.
All right. Well, this is really, I mean, lately, this is the big thing, AI. So the question is, what do you think of AI tools for
Yes. Okay. All right. So,
patents?
so I wholeheartedly, intentionally, really wanted to train to work with a company that's a very good company to train an AI system to write patent applications, particularly claims. It does not work. It simply does not work. I can tell you that straight up from firsthand experience. It does not work. It's gibberish. So there's a lot of hype about that, but I can spend 10 hours and more discussing that with you because it's a subject matter that's near and dear to my heart. However, AI tools are very good for searches because it's basically anything data analytic. It is very good. Generative, not so good. You can't in text to pictures, text to whatever. Yeah, it works. It works really nicely. But text to patent claims, ain't gonna cut it.
It's gonna have some weird stuff in there.
Very weird. Very weird.
And I'm
I
sure
tried.
you
I tried. I really did. I wanted to find an AI to replace me. I just cannot. I tried.
Okay. Any other questions? Okay. So it's not ready yet. Yeah, it's not ready yet, Raj. All right. Any other questions for Kwan? Okay. Kwan, maybe you can provide one tip uh,
Oh,
that
sure.
that founders should be aware of when it comes to patents.
Okay. So there are more tips. This is a plug for office hours that we're going to have open next week. So JJ and I are going to go on tour. We're going to have set office hours, and we're going to send out a Calendly for those of you who are interested and want more
In
discussions on
depth.
in-depth discussions on patents and or investments and business strategies as such. You'll have that, and we'll have more tips for you. So the one tip today would be to reserve money for IP, because at the beginning of any company, IP is all you have. You don't have a plant, you don't have equipments that much to count for. It's your ideas. And when it's in your head, there's not much that you can sell it for. But if it's on paper and granted and certified as such, there's some value and asset to it. So reserve some money for it because it does cost money to get it, but reserve some money for it and allocate it towards getting patents. And like I said, there's plenty of data that shows that companies with a robust IP sells and has better exits than those that don't.
Very, very cool. Well, Juan, thank you very much. I learn every time I talk to you, every time a webinar that you present. That's really fantastic. For the participants, stay on. In about 10 minutes, we have another great panel that you have to listen to. Also, it was organized by Quan, which is really great. Thank you again. So stay on. And then at 1 p.m. Pacific time, um, all the presentations will start. Today is life science only. All the presentations will be in alphabetical orders, company name alphabetical order, except for one exception. We will have a company that is from Germany that we're going to put first because they're like really late there. So we're going to have them first. But other than that, please stay on, use the tools, chat, book appointments, talk to Quan, talk to everybody. And Quan, by the way, you were requested to join a roundtable tomorrow. So we sent you an email about that. So, all right. So go visit the roundtables, talk to the entrepreneurs, talk to investors, and we will see you in a few minutes. Thank you, Quan.
Thank you, JJ. Thank you, everyone.
Bye.